All right, barrister. The briefing today was very brief, and I would like you to explain exactly in details what actually happened back there.
Thank you for giving us the opportunity to have this debrief after the hearing. I know that Southern Cameroonians, aka Amazonians, have really been looking forward to having this brief so that they understand what is going on with the case that really concerns their leaders. And we really appreciate the opportunity for you to give us this opportunity to be able to explain to them and explain to the world, what transpired today. Today was a regular hearing, and at that hearing, the chairman had asked that the Ministry of, or the Attorney General, through the Ministry of Justice, should be able to come in and proffer proof to the hearing that there was a pending case in the Supreme Court. They did not offer that proof, but they went right ahead to indicate that that case was pending, and the committee did not have any reason to doubt that that case was pending. And prior to that, if Amazonians would remember, we had put it on the record that this issue had been raised, the issue of subjudice, which is actually the principle that states that another arm of government cannot interfere or comment on issues that are pending in court. And the Public Petitions Committee, being a committee that is set up by the National Assembly, cannot comment or interfere or give a resolution or a decision on a case that is pending in court. And of course, it's very clear that this case is pending in court. We on behalf of the petitioners provided an 11-page memorandum, legal memorandum, which basically espoused our positions and what we thought about this. And we are very convinced that one of those arguments was persuasive to the chairman, and that argument specifically was that so let me back up a little and say that we had two principal arguments. One, that the Public Petitions Committee is not a court or a tribunal, and so subjudice could not apply to it. Yep. But then the second prong of that argument had 6 subsets, and in each of those we were arguing that even if the committee was inclined, like they just did, that subjudice would apply, then they should go ahead and maintain jurisdiction, because this case is so important, it's so cardinal, it's so fundamental to the violated rights of these individuals that we think that they should maintain jurisdiction. I think that that's what they've done. They've maintained jurisdiction, but they have not gone ahead to continue with it, because it would really be giving comments or interfering with a matter that is pending in the Supreme Court. So they have adjourned the case sine die. What in legalese that means is they've adjourned it until such a time when that ruling from the Supreme Court will come out, and then after that ruling they can come in with your resolutions. Because, like we argued in the memo, the decisions of this committee are not going to be contradictory to the decisions that come out of the Supreme Court. We think that any decision that comes out of here is going to be complementary of what the Supreme Court will come out with. Because there are two things that the Supreme Court can do. One, the Supreme Court can affirm the technicality that came out of the Court of Appeals. And if they do that, then they would basically be saying that, what the judgments of the 3 federal high courts here in Abuja that came down in 2019 do not hold. Or they could go ahead and overrule the Court of Appeals, which basically says that this is a technicality, because let me just refresh the memory of your listeners. The technicality that was argued at the Court of Appeals is that one of the affidavits that was deposed to by one of the clerks of counsel to the defendant or to the petitioners was defective, and that defective affidavit was caused the hearing to not have the effect that it should have had. So procedurally, that judgment was not effective. That's what we are appealing now at the Supreme Court. I hope that I'm not really getting into a lot of legal weeds, but the Public Petitions Committee today agreed that it lies squarely in the domain of subjudice, but that they are going to adjourn sine die until such a time when that decision comes out. And at such a time, they would be in a better position to then articulate the position that the National Assembly, through the Public Petitions Committee, would be able to articulate. Thank you. Good afternoon, most honorable chairman. Once again, I bring greetings from, in fact, somber greetings from the petitioners languishing in jail in Cameroon. Mr. Chairman, I did submit on behalf of the petitioners a legal memo to argue out the position of a subjudice, as was discussed in the last hearings, Honorable Chairman. And I want the record to reflect that that was aptly received, and that we can.
Save for some other authorities that save for some other authorities that perhaps we are referred to by division, and it's not different from his argument from our last meeting. So it still does not remove the fact that the court already is seized of this matter, and as such, in line with our extant law, they cannot, the House denied the authority to proceed with it.
Sorry, just to respond that I agree with you. This matter is, I don't think that any of the court decision.
Thank you.
Yeah, today is the 30th of October 2027. We are at the House of Representatives National Assembly here in Abuja, Nigeria. The hearing today was very brief because the matter, the Solicitor General of the Federation brought an issue that the case in the Supreme Court is still pending. So the chairman of the committee said, okay, we have to wait for the final verdict of that case in the Supreme Court before they can continue with what is happening, they can take a final decision on this hearing. So our prayer is that we get a very quick response, a very quick judgment from the Supreme Court, so that this matter can be terminated once and for us. And from every indications, I know it's going to be in our favor, in favor of the Nera 10. So let's keep praying and pray and hope that the Supreme Court do their job as fast as possible, so that we can rest from coming to this place always. Thank you very much, Comrade Ernesto.
We say Asawana, we say Asawana, we say Asawana, we say Asawana. To our leaders in jail, we say Asawana. People Ayoktabe, we say Asawana. Bakasan we friend, we say Asawana. gallant for. Our police soldiers, them.